Good morning, guys. Coming at you again with another video here. This is again some more information that's really helpful. This particular one is in regard to trial. I want to make it clear that from everything that I've read through the Children's Law Reform Act, to the Family Law Act, to the Child Support Guidelines, you need to understand one thing and understand it very clearly, is that all of these acts and all of these laws are geared to help the applicant. Whoever starts the court case, doesn't matter whether it's male or female or whatever, but generally the average is that it's a female that ends up starting the application and starting the court case. All of these laws benefit the applicant. There's very little information about recourse that a respondent would be able to take. Okay, and that brings me to the subject matter of this particular video, is trial. I want you to also understand too that trial is also geared to giving the applicant more leeway and more ability to prove their case than it is to give you yours. And in front of me here, I have the guide to process for the Superior Court that I've been going through, and I want to read verbatim what it is that you're expecting. So when it comes to your evidence, so when trial begins, it starts out by the applicant going first and generally starting to provide their witnesses for their testimony. Okay. So the applicant witnesses go first. When the party questions their own witnesses, is called an examination in chief. After the examination in chief, those witnesses can be questioned by the respondent party, which is called a cross-examination. After a cross-examination by the respondent, they can be re-examined by the applicant to clarify the issues raised by the cross-examination. Okay. So the applicant gets the last say when it comes to your examination. When it comes to the closing statements as well, closing statements should go through the testimony of the witnesses, given the documents have been accepted as exhibits, show the judge should agree with your position. You should only refer to the evidence in closing. When you make your closing statement orally, the applicant goes first, followed by the respondent. The applicant then has a limited opportunity to reply to the respondent's statement, and the judge may ask for closing statements to be in writing. So to sum that last little bit up, when it comes to the final remarks, the closing statements, the applicant again gets the opportunity to say the last word. So whatever it is that you do in your trial, you have to be clear, you have to be concise, you have to use the law, you have to cite the law, and you leave nothing unsaid, because the applicant will always get the last opportunity to say something. Okay, so keep that in mind, pass it along, hit the like, hit subscribe, and God bless, man.